matter of Gilbert on another and Bleakley on another.
My Lords, good morning. I
Yes,
bring this matter on behalf of the Appellants. My learned friend Mr. Goodman appears for the Respondents.
Yes.
If I can begin with some housekeeping, I hope brief. First, the matter of the new evidence that's recently come to light and relevant to at least part of the proposed ground 3.
Yep.
And in light of that, the appellant had applied seeking an adjournment of consideration of ground 3 as a means of striking a fair balance between the parties. And the court will have seen, I expect, and respondents then wrote opposing that, but indicating that they'd be content to adjourn the question of essentially how to deal with that new material on the basis that that shouldn't prejudice the appellants. We've written back to clarify that what the respondents had in mind by that was that the appellant wouldn't be prejudiced in relation to ground 3. And so I think what's anticipated is that if the proposed ground 3 proceeded today, it would nonetheless remain open at the stage of judgment for the appellant to seek directions in the light of the new evidence and potentially to revive aspects of ground 3. All of that would remain to be determined at the stage of judgment and directions at that stage. That's a position agreed between the parties. If the court therefore is content to deal with matters in that way.
Well, I think what we thought is that we'll see how we get on with
Yes.
the matter as the day progresses.
Yes.
But we understand what the party's position is, and we'll see what our position is later in the day.
Lord, I'm grateful. And then just in terms of the approach to this hearing, very much the bulk of my submissions are focused on the permitted ground 1.
Yep.
What I proposed to do was to run my arguments on the permitted ground and the proposed grounds together as the most efficient way of dealing with things. That would leave it open to the courts to indicate in relation to the proposed grounds that my learned friend needn't address your lordships on either or both of those proposed grounds if I've done that badly at that stage. But otherwise, in my submission, that's probably the most efficient and sensible way to proceed, again, if the court is content with that part.
We're conscious that although we have started slightly early, got quite a lot to get through today.
Yes.
And I'm sure you're both aware of that, and you'll do your best to do so. We're aware that there is, I think, a further action that is being pursued, and I think my Lord Justice Foxton has just some inquiries about that and the progress of it and what's happened within it.
Is it right? Claim has been brought under section 423 of the Insolvency Act.
It includes the claim under section 43 and the conspiracy claim.
And is there a constructive trust element to it as well?
There's an element, yes.
What's the current sort of procedural status of that part of your enforcement effort?
The status is that it is being progressed. There has not been an acknowledgement of service from the defendants. I think that is where matters. Yes, so it's been served, but that is as far as matters have progressed at this stage.
And what a sort of has a backup freezer been sought in respect of those claims?
Not at this stage.
Obviously remains an option.
Yes.
Did you obtain permission to serve those proceedings out of jurisdiction?
Yes.
Right.
Presumably 43 under the enactment gateway.
Yes. Yes. So, Lord, that is the position in relation to those other proceedings.
Yes.
I'm sorry, who are the defendants to those proceedings?
They are the respondents to this bill. And Broadoak and Mr. Bleakley.
So that's in the background of all of this, obviously.
Yes.
Yeah.
The approach we've taken is that I accept that that's relevant background that your lordships will want to have regard to as a matter of background. It's not relevant to the issues of law which are confined and about the existence of a gateway that arise on this appeal.
Yes.
Obviously, depending on the outcome of the appeal, those matters are relevant to how things could proceed from there. But no steps have been taken.
Right.
That
I mean, speaking just for myself, yes, just thinking how matters could progress and the, as it were, the utility of what we're doing today. But anyway, there we are.
well, to some extent, where we are is a product of how things proceeded chronologically.
Yes.
And it can happen in litigation that a path is taken, one
I
finds
understand.
oneself in a position where a point has practical significance, even though if things had proceeded in a different order, that point would have arisen.
Yep. Well,
So,
understood. All right. I think we've all said enough, probably. Thank you very much. Yes.
I'm grateful. So, ground one, by way of roadmap, my submissions are divided into 3 topics. The first topic concerns relevant aspects of the freezing order jurisdiction. It has 4 subtopics. First, the genesis of Section 37 of the 1981 Act as it relates to freezing injunctions. Second, the relationship between Section 37.1 and Section 37.3 of the 1981 Act. Third, whether Section 37 now contains the court's power to grant a freezing injunction. And fourth, the true nature of a freezing injunction, essentially in light of the broad idea. That's my first topic. My second topic concerns relevant aspects of Gateway 20. That has 2 subtopics. First, the general approach to construction of the gateway, and second, the approach to the construction of the gateway taken by this court in the Erexon case. My third topic is then the application of Gateway 20 to an application for a freezing injunction in circumstances such as this, and that has 3 subtopics. First, how the appellant says the gateway applies in light of what the court will by then have heard on the first 2 topics. Second, the first instance judge's reasons and the respondent's further reasons on appeal for rejecting that approach. And third, stepping back, why the outcome contended for by the appellant is the right one. By way of preface to the detail, I say that the answer to this appeal is provided by the combination of the reconceptualisation of the freezing order jurisdiction in broad idea on the one hand, and on the other hand, the broadening of the gateway for enactments that took place in 2009. In light of those developments, I rely on 3 key propositions. First, the application for a freezing injunction is freestanding. It permits an applicant with no other right against the respondent to apply to the court to protect his interest in enforcing an existing or future judgment. Second, the power of the court to grant the applicant such an injunction is now a statutory power under Section 37 of the 1981 Act, and that statutory power is expressly extraterritorial in scope. And third, I say it follows straightforwardly from those 2 propositions that where the applicant makes the procedural claim for such an order under Section 37, it's Section 37 which allows those proceedings to be brought, and the claim therefore falls squarely within the express words of Gateway 20, and we say, in essence, well, there's a lot of detail, it's as simple as that. So I turn against that background to my first topic, relevant aspects of the freezing injunction jurisdiction, and the first subtopic, the genesis of Section 37 as it relates to freezing injunctions. Section 37 was, of course, enacted as part of the Senior Courts Act in 1981. My first point about the legislative history is the distinction between provision for the power to grant injunctions generally and the power to grant a freezing injunction. The power to grant injunctions generally was, of course, already on a statutory footing. That was in the form of Section 45 of the Supreme Court of Judicature Consolidation Act 1925, and before that, Section 25(8) of the Supreme Court of Judicature Act 1873. And as has been repeatedly emphasised in the authorities, those were extremely broad statutory powers, albeit hemmed in by principles as to how broad power is to be exercised as developed in the case law. That's Section 37(1). Section 37(3) was, by contrast, unprecedented in the sense that there had been no earlier statutory provision freezing injunctions, or expressly referring to freezing injunctions, and of course that power had not been thought to exist before 1975, when the Court of Appeal made its decisions in the Nippon case and the Morava case. And that leads me to my second point about the legislative history, which is that at the point at which Parliament intervened in respect of the new freezing order jurisdiction, that jurisdiction was unstable. And that was so in two related respects. First of all, there was at least some residual doubt about the existence of the new jurisdiction at all, because one had Court of Appeal authority in Lister and Studs. We haven't in the bundle, I don't propose to go there, but where the Court of Appeal had essentially refused to countenance such an order. In Morava itself, Lord Justice Roskell acknowledged that injunctions in that form had been applied for many times in the commercial courts and had been consistently refused. And although a freezing injunction case then reached the House of Lords in 1977 in the Susquehanna, the success of that appeal on the point about the construction of the injunction service gateway meant that the House of Lords didn't directly consider the validity of the new practice. But second, there was a particular controversy about whether the new type of order could be made against defendants resident in jurisdiction. And if we could just pick up what was said about that by Lord Helsham in the Susquehanna, that's in the first bundle of authorities behind tab 7, and page 112. Sorry, that's the numbering on the bottom right. 112.
Sorry, what was the number again?
It's page 112
Thank you.
in the numbers at the bottom. And if I could ask the court just to pick up at the paragraph beginning just after letter D, the so-called moreover injunctions, and just read to the end of that page. So Lord Hailsham is perhaps making some subtle digs about the jurisdiction generally, Lord Denning's in a sense new jurisdiction. But what Lord Hailsham certainly regarded as unacceptable was a differential treatment of foreign-based and resident defendants. And he suggested in terms that the legislature would have to intervene to put them on an equal footing if the new jurisdiction was to continue. Before Parliament had settled the position, the point arose in a flurry of cases, and if we could quickly look at one of those, case of Rahman and Abu Taha, it's in the same authorities bundle at tab 10. And if I could ask the court to turn up page 132. And if I could just ask the court to read all the way, if I may, from letter G on page 132 to the end, letter A at page 134. And so Lord Denning there is effectively taking up the challenge set for him by Lord Hailsham.
Leave it to the
Well, he wants to perhaps preempt the legislature, protect his innovation, might be a cynical interpretation of what's going on. But in any event, the solution he arrives at is that of, I particularly rely on what's said at page 133 in the bundle number between E and F. The solution he arrives at is that of putting all defendants on the same footing, no matter whether they be foreign-based or English-based. The same principle applies to both. That's then echoed in debate on the second reading of.
Now, is that material admissible? And have you complied with the Hansard citation practice direction in relation to it?
Well, I rely on this as helpful contextual material. I'm not sure that we're dealing with a hard point in the sense of statutory construction in relation to this. And so, in my submission, it's helpful for the court to have regard to that background material. There's perhaps room for argument.
There is a certain sort of judicial nervousness when taken to parliamentary debates about the very statute which is an issue, and there are fairly strict tram lines, aren't there, for
Well, in a sense, I didn't push the point because I submit it's also plain from the consonants between the language of section 37.3 itself and the background of that very recent case law, that there's a direct connection between the two, and which is helpful to an understanding, therefore, of what Parliament was seeking to achieve by enacting that provision. And so what we say is that the reason for making specific provision freezing injunctions by section 37.3 one can plainly infer was that the existing law was unstable. One can see that from a flurry of cases in these two particular respects, that the new provision stabilises the position for. First, it confirms the existence of the power to grant a freezing injunction. But second, it also stabilises the position on jurisdictional reach. My learned friend relies on the background to that being a doubt about whether the power can apply to domestic defendants, and I don't disagree with that. That's right. But the problem that was perceived to give rise to was that of differential treatment, and the solution arrived at by Parliament is to put defendants, whether they be resident or not, on an equal footing, and that is what the express words of section 37.3 do, and necessarily inherent in that is a specific intention on Parliament's part that the new statutory power could be exercised against defendants outside the jurisdiction in the same manner as it could be against those within it. And it may be worth good to just so people has it in mind the wording of position 37.3. That's in the third bundle of authorities. 56.
It's actually in my fifth bundle. I don't know.
Oh, I'm
whether
sorry.
they're all, it's all right. It's just that they're probably organised differently. But we've got 6 bundles. So I think it's in.
What tab is it?
56.
It's tab 56. And so what it provides is that the power of the court under subsection 1, I'll come back to that, to grant an interlocutory injunction restraining a party to any proceedings from removing from the jurisdiction of the High Court or otherwise dealing with assets located within that jurisdiction. In other words, to grant a freezing injunction shall be exercisable in cases where that party is, as well as in cases where he is not domiciled, resident, or resident within that jurisdiction. Well, that takes me to my next subtopic, which is the relationship between section or subsection 37.1 and subsection 37.3. I can take this point quite shortly because, in a sense,
just on the wording. I mean, I know you're going to come back to that, but just to note that at this stage, it's talking about doing things in respect of assets located within the jurisdiction.
I accept that, and that's relevant, in fact, in the light of subsequent case law and how the reasoning of Babnaft works, that there's the reference back to section 37.1.
So
in a sense, this is
when we get on to international moravas, worldwide moravas as they're known, that can't fall within the terms of subsection 3, because subsection 3 is concerned with assets within the jurisdiction.
In a sense, this is my next point, because it's not.
Sorry, I don't want to take you out of.
No, but it's directly relevant to what I was coming to, because I don't say that these subsections are to be read in isolation from each other. I plainly can't say that, because subsection 3 expressly refers back to subsection 1, and so it's expressly a gloss on subsection 37.1. I don't seek to cast doubt on that for a moment. What I rely on is the fact that in relation to freezing injunctions, Parliament has expressly legislated for the reach to respondents outside the jurisdiction. I'll return to that, as I'll also return to the relationship of Gateway 20 to freezing injunctions may be different from its relation to other types of injunction under section 37.1, and I'll come back to that. And I don't suggest it's a point the court needs in terms to decide. But I don't say, to repeat, that sections 37.3 and 37.1 should be construed as providing separate and distinct statutory powers. And so to return to your lordship's point about the jurisdiction for worldwide freezing orders, the court's starting point is section 37.3 in Babnaft, where this is done. I think the way it extends the orders to a worldwide basis is by reference to the breadth of section 37.1. But that's perfectly consistent with 37.3 operating as a gloss on 37.1 and providing important things about the freezing injunction that Parliament has specifically legislated for. I do suggest there's some degree in that development of the courts welcoming the position that one could find a rationale for extending the freezing order jurisdiction to worldwide assets, and not finding that it was constrained by those words of 37.3. It doesn't mean that somehow thereafter section 37.3 falls away for purposes of any worldwide freezing injunction. It was only on that specific aspect of the development of the jurisdiction that one had to have resort back to 37.1 and the breadth of the powers to grant injunctive relief to expand the jurisdiction in that way. Well, my third subtopic is whether my own friend is right to say that section 37, and I quote, confirms but does not contain the court's power to grant an injunction. I respectfully suggest that's something of a red herring, and that there's no doubt that the power of the High Court to grant freezing injunctions is a statutory power now conferred on it by section 37 of the 1981 Act. And so, just to make matters plain, if I could ask the court to look at the South Carolina case. This is in my first bundle of authority, perhaps the court's bundle 3, but it's tab 12 of the authorities. And page 164. And this is the speech of Lord Brandon with which the other members of the court agreed, albeit that Lord Gough cast some doubt on categories that he referred to in the passage I just asked the court to look at. But
Mr. Is this page 39?
Yeah.
Exactly. And so I asked the court just to look at letter H, beginning the paragraph beginning at letter H towards the bottom of that page. And he sets out certain basic principles governing the grant of injunctions by the High Court. The first basic principle is that the power of the High Court to grant injunctions is a statutory power conferred on it by section 37(1) of the Supreme Court Act 1981. And then he quotes it. And it's perhaps just relevant to note also what he says about section 37(3). If the court skips to page 165 or 40 on the internal numbering, next to letter H. The power of the court to grant moreover injunction may also, before it was statutorily recognised, have been a further exception to the second basic principle stated above. So in his categories, he had one of them was unconscionable conduct, and he said that. But that power, however, has now been expressly recognised by section 37(3) of the Supreme Court Act 1981. What my learned friend seizes on in this respect are judicial statements that, in my submission, really concern the origins of the court's power to grant injunctive relief. But with respect, it's a misunderstanding to treat those statements as seeking to cast doubt on the position that Lord Brandon set out, that the court's power is now statutory. Their purpose is to cast light on the principles going to the court's development and application of the statutory powers. And just to exemplify and make that point good, if I could ask the court to look at the Wolverhampton case, that's behind tab 47. And page 1375. This is the speech of Reed, Briggs and Kitchen.
Sorry, could you give us a page number again?
1375.
Thank you.
And I think this is one of the pronouncements that my learned friend refers to and relies on, where the Supreme Court says the injunction is equitable in origin and remains so despite its statutory confirmation. But the purpose of what the court is analysing there is to understand how that statutory power can appropriately be developed. That's the context in which it's referring to the equitable origins of the statutory power. And that's made even plainer if one then looks forward to paragraph 21, for example. It's often been recognised that the width and flexibility of the equitable jurisdiction to issue injunctions are not to be cut down by categorisations based on previous practice. And then paragraph 22, having referred to various dicta about the recent developments of the law of injunctions, they illustrate the continuing ability of equity to innovate both in respect of orders designed to protect and enhance the administration of justice, such as freezing injunctions and so on, and also, more significantly for present purposes, in respect of orders designed to protect substantive rights. But my point is that in addressing the equitable origins of the statutory power, the Supreme Court there is concerned to address the principles applicable to how it can be developed, and says in that context that the equitable origins are of continuing significance. And I don't seek to cast any doubt on that. What it's not saying for a moment in that submission is that it's not a statutory power, and where a party seeks and the court grants an injunction, the court is exercising anything other than the statutory power provided by section 37. My argument in no way relies on section, I don't submit, but section 37 in any way supplies some statutory code in relation to injunctions. And again, that's the essential point being made in these pronouncements, that the courts can continue to have regard to the principles and authorities predating the statutory provisions. But again, that doesn't in any way cast doubt on the fact that what the court is now concerned with, and is relevant for present purposes, is a statutory power. I don't argue, lately, with it being essentially a confirmatory statutory power, but again, that doesn't alter the fact that it is a statutory power, and where an applicant seeks the exercise of that power, it will be seeking the exercise of the court's power under section 37. That leads to my next subtopic, which is the true nature of the freezing injunction. And as I indicated at the outset,
Can I ask about Foreign LaRue, which I think is the one of the authorities Mr. Goodman places particular reliance on when identifying the relationship between the equitable jurisdiction to grant injunctive relief, I think, in section 37.1. Doesn't Lord Scott address this issue in terms? If I remember right.
well, I don't accept that he does that in a way that casts doubt on the characterisation that I've just given, because I'm not sure he anywhere says that what he. Sorry, I should say in the Wolverhampton case, of course, in the passage I've just taken the court to, express reference is there made to Foreign and LaRue, and so to some extent, in my submission, how what Lord Scott says in Foreign and LaRue is to be understood in the context of how it's then explained in the Wolverhampton case, and where it's made clear that the significance of it being remaining an equitable jurisdiction is in the court's ability to have regard to the case law and the broader equitable principles that informed its historical development. But I don't take Lord Scott to be saying anything that that casts doubt on that. Perhaps I could pick that up further in reply, based on what my then friend says about it. Lord's the true nature of the freezing injunction, and by that I mean, in particular, what the Privy Council has determined in that respect in Broad Idea. That'll be familiar to the court, and I won't labour the submission. But I highlight 3 points in relation to that decision. decisions at tab 40.
Sorry, tab.
40.
Thank you.
And if we could begin at paragraph 83 on page 1179. And I could have gone to a number of paragraphs, but this is the headline points that it was decided by the Privy Council that a freezing injunction is not a material analysis ancillary to a cause of action in the sense of a claim for substantive relief, and in this respect, this does not represent good law. And the justification for the jurisdiction was put principally in terms of the enforcement principle. And in relation to that, and that's my second point, if the court could turn over the page to page 1180, look at paragraph 88, where there's discussion by Lord Legate, I think the majority agreed, of the enforcement principle. So I just highlight that he made specific reference in that context to the Chabra jurisdiction. And that's one of the things that was inconsistent with the rationalisation in the scheme there. And in particular also what Lord Legate said at paragraph 89 about the nature of the interest which the applicant has and can seek protection for in such a case. And if I could invite the court just to read paragraph 89. So, Moles, what I rely on is that, as Lord Legate says there, the applicant has a right, in inverted commas, which he can seek to protect by an injunction, but it's a right of a crucially different character than the right on which a cause of action is based. And the right is the flip side of the interest that the applicant has in protecting an enforcement process. Lord Legate doesn't put it in terms of standing, but it's that interest, at least by implication from what he says, that gives the applicant a procedural right to apply to the court for that protection. And the third point I make about broad idea is just how matters operated procedurally in that case, because the situation in that case was that the applicant, a Hong Kong company, sought a freezing injunction from the BVI court against a BVI company in anticipation of proceedings to be brought in Hong Kong, and of course the BVI had no equivalent of Section 25 of the Civil Jurisdiction and Judgments Act 1982. It did have a statutory provision in similar terms to Section 37(1) of the 1981 Act, or rather closer actually to the similar provisions of the 1925 Act and an 1873 predecessor English Acts. If your Lordship's notes, one sees that from paragraphs 74 and 76. But what the Privy Council held in those circumstances is that it would be open to an applicant to seek a freezing injunction, notwithstanding the absence of any right other than the interest arising from the enforcement principle, for which it could seek protection by application under section 24(1 of the BVI Act, paragraphs 101 to 102. In other words, there was no other procedural aspect of that procedural right referred to other than the statutory power to grant an injunction under the BVI legislation. And I also draw attention to paragraph 118. I should say this is all in the speech of Lord Mayor, where he says in terms that the same could be done under section 37 of the 1981 Act. The context of that is that he's saying it doesn't matter that Parliament has in the meantime also enacted section 25 of the CJJA. Notwithstanding that, it would remain open to an English court under section 37 to grant such a freezing injunction in support of foreign proceedings. And I'll return to this, but what I ask the court to note again is that there's no hint there of anything else that, in inverted commas, allows those applications other than the statutory injunction jurisdiction as they're interpreted. Well, that's the end of my first topic. And
was there an sorry, on that case, was there an equivalent of Gateway 20 under
They
there?
were served in the jurisdiction.
Yeah.
because
But I wonder whether there was an equivalent under the BVI
I
rules. Just a
think
matter of
I'm
interest.
right in saying that there is not, but it didn't
It didn't arise.
because what they did consider was the injunction gateway, and we'll come to that.
Yeah.
But there was the defendant who was in the jurisdiction, and then the other one where they said that he couldn't be, or sorry, it couldn't be served.
But for what it's worth, that's also my understanding that there wasn't a gateway, but I'll try and check that. There wasn't an equivalent of the enactment gateway in the BVI rules as they then stood at the time.
Right.
Was my second broad topic, which is relevant aspects of Gateway 20. Perhaps we can just have to hand to remind of the words of the gateway. We've got a supplemental bundle of authorities just containing the gateways, which is meant to be helpful. Maybe it's unhelpful to have that rather than the white book. But in that supplemental bundle, if that is helpful, it's behind tab 2 and has the practice collection. Otherwise, in the white book, it begins at page 331 and gateway textbooks to page 334. But all I ask the court to call is that what it provides is as a gateway where a claim is made under an enactment which allows proceedings to be brought, and those proceedings are not covered by any of the evidence referred to in this paragraph. Well, my first subtopic on this topic is the general approach to construction of the gateway. My learned friend says that the essential task is to ascertain the objective intention to be attributed to the Rules Committee, and in principle I agree with that. The intention we're specifically concerned with, it's important to recall, is that in connection with the introduction of the present Gateway 20, which came into effect from October 2009. And prior to that, the practice direction stated a number of specific enactments for which a gateway was provided. And that's actually in that supplemental bundle of authorities. If your lordships wanted to look at that, then you point in tab 1. Your lordships have the provision that existed, version of practice direction that existed before that revision in effect from October 2009. I should say also that we've looked for any materials that would shed light on the Rules Committee's subjective, perhaps, intention, but had a nil return on that.
Not all those involved in these reforms are so good as to produce reports of their work.
No, there seems to be there's limited availability, I think, of minutes, even where they may have existed in the past. But I emphasise there's no reason to infer that the Rules Committee, in making that change, had any intention that was specifically concerned with section 37. What one clearly has to infer from the words introduced against the background of the ones they replaced is an intention to move to a gateway catering for enactments on a general, as it were, catch-all basis, necessarily encompassing even enactments that may not yet exist. And so I just emphasise that it wouldn't be right to assume that the Rules Committee have necessarily entered into any consideration of the impact of that broadening of the gateway in relation to specific enactments. The effect of what it did was that it, as it were, lost control over the enactments that the gateway would be operative in relation to. And just on the general effect of that change, I could take the court quickly as a decision we'll go back to, but the first instance decision in the Gorbachev case of Mr. Justice Jacobs, that's at paragraph 76, sorry, tab 76. And sorry, it's not. I'm so sorry. It's not tab 70. It's tab 42, and it's paragraph 76, which is on page 1241. And I just pray and named what Mr. Justice Jacobs said there, referring to that rule change. The relevant rule change brought into effect the very general wording in Gateway 20. The previous equivalent rule had specified a number of statutes, and the SCA was not amongst them. Well, this was a quite deliberate change from the specific to the general. Changes discussed in the decision in Wrexham. Its effect was plainly to bring within the purview of Gateway 20 a large range of enactments which could not previously be relied on. And in my submission, that's plainly correct. And this court, indeed, has already settled the position as to the construction of that gateway. In particular, in that there's no justification for giving it a narrow construction. And that's my next subtopic, which is the approach to Gateway 20 in the Wrexham case. That's at tab 35, it would be in the same bundle.
It may be authorities bundle 3.
Yeah.
Particular page.
I'm sorry, so page, if we could start at page 1005. And that case concerns the availability of Gateway 20 for purposes of seeking out a claim under Section 43 of the 1986 Act. Lord Justice Lewison gave leading judgment, which the other Lord Justices agreed with. If we could just pick it up at paragraph 32. And I note and rely on Lord Justice Lewison's observation that given the extent of the court's powers under Section 43, and what he's referring to there, I suggest, is their extraterritorial reach, I would a priori expect procedural rules to exist to enable the court to exercise those powers. And if I could ask the court to read then paragraph 33 up to the quotation from Lord Sumption's speech in the Appellant and Badrani case. So I rely on his analysis that it must be implicit from Gateway 20 that the enactment in question must allow proceedings to be brought against persons not within England and Wales. Otherwise, it would be extraordinary width. But it is not easy to see any other limitation from the words of the paragraph itself. And then really turns to the question of whether there could be a limitation from any other source, from general principles of construction. To cut to the answer is no in my submission. If I could ask the court to look at paragraph 35, and here he says, having referred to what Lord Sumption said in Appellant Badrani, and then also Appellant 1, that the key point is that the question of construction of the gateways is a neutral one. There's no presumption in either direction. He then considered a case decided under the earlier RSC wording, which decided that an unfair prejudice petition could not be served out without leave. It wasn't actually about gateways, but the provision for service out without leave. And if we could pick it up again at paragraph 42, if I could ask the court to read all the way to paragraph 44 inclusive. So he considers in those paragraphs the history behind the present version of Gateway 20. And then paragraph 47, he reaches his conclusions that there is power to permit service out of section 43 under Gateway 20. And I emphasise that as part of the justification for that he puts weight on the fact that the court can still exercise at the discretionary forum convenience stage control to ensure that there is a sufficient jurisdictional nexus in the circumstances of the particular case. And so he is in the middle of paragraph 47, or about a third of the way down by letter F. The court must still consider whether to grant permission. That is a strong pointer against implying any restrictions into the ordinary meaning of the gateway. And I again rely on the relevance of that here, and perhaps just pause to note in relation to that the debate perhaps that emerges from the Supreme Court authorities about the role of the forum convenience discretionary stage, because in Lord Sumption in Brownlee 1 had suggested that the forum convenience test was a stage of a rather different nature than that served by the gateways themselves. It was rather more focused on the practicalities of the litigation rather than the question of the jurisdictional nexus itself. In Brownlee 2, that was dealt with by Lord Lloyd Jones. That's in the interest of... Sorry, if I may, I'll just take the court there, because I think it's a significant point. So it's behind tab 39 and page 1106 in that tab. And paragraph 77, there's reference to what Lord Sumption had said in Brownlee 1. And then paragraph 79, what Lord Jones says, with whom the majority agreed on that appeal, that the discretionary test of forum non-convenience, well established in the law, is an appropriate and effective mechanism which can be trusted to prevent the acceptance of jurisdiction in situations where there's merely a casual or adventitious link between the claim and England. Where a claim passes through a qualifying gateway, there remains a burden on the claimant to persuade the court that England and Wales is the proper place in which to bring the claim. And of course, there's been the academic debate about this, but the general pattern is clear. There's been a gradual broadening of the gateways and a greater emphasis placed on the forum convenience discretionary stage. And Lord Lloyd Jones there endorses that approach. He's not endorsing some sort of free-for-all, the Professor Briggs view of the world in which the gateway should perhaps fall away altogether. He's not doing that. But equally, he is endorsing the notion that one shouldn't artificially seek to restrict the gateways, construction of the gateways, out of a fear of overly broad jurisdictional connections, having regard to the fact that there is this further stage by which the court can exercise control. And that's absolutely in line with what Mr. Justice Lewison said in the Erexon case, in the specific context of Gateway 20, and as it applied on that case to claims under Section 43. And we don't need to go back to Erexon, but I just noted paragraph 48, where Justice Lewison records and rejects an argument that the effect of the words which allows proceedings to be brought in Gateway 20 is that to come within the gateway, the enactment must expressly authorise the bringing of proceedings against persons outside England and Wales. Of course, I say that this is a case where the relevant enactment does expressly authorise the bringing of the relevant proceedings against persons outside England and Wales. That approach to the construction of Gateway 20, in other words, the approach set out by Lord Justice Lewison, was then also applied by this court in Gorbachev and Guriev on the appeal of that case. We could just turn now to that. That's behind tab 43. And page 1261. The discussion begins at paragraph 20. This is a judgment of Justice Nails, with which the other Lord Justices agreed. And essentially, paragraph 20, there's extensive reference to the analysis in Erexim, and then I rely on paragraph 21. What Lord Justice Nails takes from that case is that if an enactment allows proceedings to be brought against persons not within the jurisdiction, Gateway 20 is potentially applicable, and in deciding whether it does apply, there's no justification for giving the Gateway a narrow construction. And the rationale behind that, perhaps not stated quite in terms by either case, but I'd suggest it's the one at least indicated by Lord Justice Lewison, that if Parliament, even implicitly, wishes a claim to be exercisable against a person abroad, it's natural to expect that ultimately its own procedural rules, those rules also being statutory, don't subvert that intention. And having laid those foundations, my third topic is the application of Gateway 20 to an application for a freezing injunction. My first subtopic, the appellant's case as to how it does apply. And my submission is that once it's recognised that there's a self-standing right for an applicant to seek a freezing injunction under Section 37 of the 1981 Act, which expressly allows the applicant to seek such an injunction against a person resident outside jurisdiction, it's obvious that the application falls within Gateway 20. On any view, the application is made under an enactment, Section 37, which allows those proceedings to be brought. And that's my submission, obvious even on the ordinary meaning of the words of Gateway 20, and all the more so given the broad construction of the Gateway, which the authorities mandate.
Well, they mandate a neutral construction.
Well, that's fair. Although,
neither narrow nor broad, I'd suggest. Neutral.
That's true, but what I rely on, though, is not just that general principle of construction, but the particular approach to construction of Gateway 20 in Erexim. In other words, that other than the requirement for the enactment to authorise proceedings against defendant outside the jurisdiction, it's not easy to see any other limitation on the scope of the Gateway. That in my submission is Lord Justice Lewison's approach to how one looks at that Gateway. It is strikingly broad, but that is the position that's been held to be the effect it has. And as I say, it can be rationalised in the terms that I've submitted. But as I say in my submission, that broad point has already been settled at appellate level by those two cases. Well, to put some flesh on the bones of how the submission I've just made operates within the framework of the CPR as a matter of procedure, CPR Rule 6.36, of course, provides that the claimant may serve a claim form out of the jurisdiction if any of the grounds in the practice direction applies. The first instance judge here accepted, and it's accepted by the respondents on appeal, that the word claim in this context encompasses a procedural application commenced by application notice. In other words, the type of application that was in fact made that counts for these purposes as a claim. That reflects the conclusions reached in Gorbachev. And I wonder if we can just turn up again the first instance decision in that case. That's at tab 42. And I could ask your lordships to turn to page 1239. And that was a case about service out under Gateway 20 of a third-party disclosure application, and Mr. Justice Jacobs held that that was permissible, and this court agreed. If I could ask the court to look at paragraph 64, and I take the court to that because it's also material to the meaning of the phrase within Gateway 20 itself allows proceedings to be brought. So that's where Mr. Justice Jacobs finds that there, Rule 6.39 applies to applications which can be described as being of a procedural rather than substantive character. And against that background, can I ask the court to read paragraphs 65 to 69? And in this court, Lord Justice Mayles specifically agreed with that analysis of Mr. Justice Jacobs. For your lordship's note, that's at tab 43, page 1267, paragraph 35 in the judgment of Lord Justice Mayles. And I submit that the same analysis in its essentials applies here. As between the applicant and the Chabra defendant, the application notice seeking an order under section 37 is the originating process which commences proceedings seeking that order. It's clearly section 37 which allows those proceedings seeking an order under section 37. I then turn to my second subtopic against that background. What were the grounds on which the first instance judge found Gateway 20 inapplicable, and also the further grounds relied on by my learned friend on this appeal? The first point, and central to the first instance judge's approach, were the Obiter comments of this court in the AES Öst-Kammergorsk case, suggesting that Section 37 was not an enactment falling within Gateway 20. That wasn't a freezing injunction case, it was an anti-suit injunction case. If I may, I'll deal with it. We've obviously got it in the bundle, but I'll deal with that by reference to the analysis of it, again, in the first instance decision in Gorbachev and Guriev, partly because the first instance judge in this case was sort of connected to that. Again, it's tab 42, and we could look at paragraph 35. Sorry, I think I've got an erroneous reference there. If we could turn to paragraph 80, and I pause to note that this aspect of Mr. Justice Jacobs' analysis was also endorsed by this court in the judgment of Lord Justice Mayles, and that's where my reference to paragraphs 35 to 36 came from in the Court of Appeal judgment at tab 43, 1267. But if I perhaps invite your lordships just first of all to read paragraphs 80 to 82. And Lords, in my submission, the reason Mr. Justice Jacobs regards the reasoning in the AES case as inapplicable to sections 33 or 34 of the Senior Courts Act, say the pre-action third-party disclosure jurisdictions, it is telling. It's because, as he says in paragraph 82, those sections, he says, provide a right to make an application against a non-party that's not ancillary to other remedies sought in existing proceedings against those parties. It's a self-standing right, or permits self-standing proceedings in the case of those statutory provisions. And in my submission, that accurately encapsulates the Obiter reasoning that one can deduce from AES, where the reasoning is actually extremely brief. But that is the essence of what the Court of Appeal said Obiter in the OES case. Its premise is that Section 37 doesn't provide a self-standing right to seek an injunction, and the injunction can only be sought in support of substantive legal rights to be found elsewhere. In other words, the position thought to apply to freezing injunctions as well as other types of injunctions at that stage. And, my lords, one can quite see the objection to describing Section 37 as, in the words of Gateway 20, allowing the proceedings in which an injunction is sought if premises that no injunction could be allowed absent some other substantive basis for the proceedings to which the injunction was ancillary. I don't say that that's necessarily correct, but one can quite understand that perspective. But so far as freezing injunctions are concerned, that is, of course, Susquehanna reasoning. And there's the observation that of Justice Ricks that Mr. Justice Jacobs quotes, where he says, if it were otherwise, the Susquehanna would now be decided differently. Of course, it would now be decided differently. And that was rightly noted by Mr. Justice Jacobs in his in noting that those obiter observations in the AES case would require reconsideration. And in my submission, there's a further important point, which is how Mr. Justice Jacobs did not distinguish sections 33 and 34 from section 37 in the context of that case. He did not distinguish them on the basis of whether they contained a specific procedure for invoking the statutory right. And that's an important contrast to the first instance judge in this case, who proceeded on the basis that to come within Gateway 20, the enactment must establish, and I quote, a specific procedural right to make an application. In other words, seeming to suggest that the statutory provision must spell out must almost be self-contained in setting out a procedural mechanism for making that application, rather than working in tandem with the CPR. But of course, all statutory provisions enabling a claim to be made operate to some greater or lesser extent in tandem with the CPR and the wider body of procedural law that determines how those claims are in practice to be made. On that aspect of how the first instance judge approached matters.
Can you just show us how he put it exactly? So
yes, because I made it. So it's paragraph 79, and so in the core bundle, page 115. And his own observations are by reference to Gilbert. And perhaps if your lordship just read paragraph 79, bottom of page 115.
I'm not quite sure what a specific procedural right, exactly what that means. I mean, you might well say there's a specific procedure for making a claim, but maybe that's what he had in mind.
I think it is. It's fair to say that one gets more from sections 33 and 34 than one gets from section 37 about how a procedural claim is to be made under those provisions. And of course, they make specific reference to the rules in the CPR. Really, there's a whole range of approaches in statutory law.
I think section 423.
Well, and I rely on that because 423 in my submission certainly doesn't go at all far to provide for these matters. And in all cases, as I say, even in the case of sections 33 and 34, if one perhaps puts to one side the specific reference to the rules in 31, 16, 17, all of those provisions still have to work in tandem with, among others, Part 6 of the CPR. And so in my submission, that just wasn't a defensible basis for distinguishing between section 37 and those other types of those other enactments which have already been held to fall within the gateway. As your lordship says, section 43. And
it might be said here, if you want an injunction, then there is a procedure, namely part, I think it's 23 of the CPR, which requires an application notice. And then there are circumstances which are well established in which you can do it without actually serving the application notice, but have to undertake to issue one. And so it could be said, I suppose, that there is a specific procedure at least, which is part 23.
yes, I think the first instance judge's complaint though was that was not actually contained in section 37.
Yeah.
But in my submission, that just doesn't take matters anywhere, because by their nature, these types of procedural provisions are rather scattered, and one's dealing with a range. But I can't think of any statutory provision allowing a claim to be made that provides some complete code so that one needn't ever open the CPR and still be able to bring that claim.
What about this distinction, though, that section 37 is ostensibly aimed at defining the powers of the court. Now, ironically, it appears with the same subheading in the Senior Courts Act powers as sections 33 and 34. But nonetheless, within it, you get language recognising the fact that there will be someone who will be invoking that power.
Yes.
And section 44 of the Insolvency Act, similarly,
Yes.
recognises that there will be someone invoking that power. So you might say that there are indicia there that this is loose language, and I apologise, but sort of right conferring legislation. Now,
Yes.
we don't have that on section 37, do we? It's all court focused.
Well, but in my submission, one still has to consider the statutory provision in the light of the decisions of the court as to how that power operates. And
I've not looked at the various enactments that used to be specifically listed before the 2009 change. I think you made some points about those. But is it fair to say that they all contain language contemplating the bringing of a claim by a claimant? And to that extent might also be distinguishable from section 57.
I think we say that one or two of them didn't, and then
Right.
we disagree about that.
Right.
I didn't seek to place a great deal of emphasis on that, because what I emphasise is that, of course, there's this deliberate broadening by the change and the creation of Gateway 20. But I submit that if one's focusing on section 37, what the courts have clearly held in relation to the operation of that section is that an applicant can seek an exercise of that power. And then one asks rhetorically, what else is the source of that right that an applicant has? if it's not section 37. That's really what it amounts to. It's clearly a statute that in being passed by Parliament has to carry with it an implied intention that it will be possible for a party to invoke an exercise of the power it provides. And clearly, as well, that can only be done by way of proceedings. That's the context of the civil justice system within which that provision is being enacted. So when one puts that together, in my submission, one can't draw any distinction on the basis that there's no express procedure or even reference to a procedural right within the wording of section 37. What I also submit is that to impose that type of limitation on the gateway is a significant narrowing of it. It's a significant gloss that isn't there on the express words, on the ordinary meaning of the words. And again, it's a plain and significant departure from the approach to the construction of that gateway that the Court of Appeal in Erexim and then again in Gorbachev held to be the appropriate one. So in my submission, that takes one amply far.
But on one view, and I think this was in part what might have been animating me on a wet night in Manchester in November 2024, because we have had a series of decisions on other issues pushing the boundaries. You have Erexim adopting that very broad expansion of Gateway 20. You have Gorbachev applying it to a procedural power for the production of documents, which was innovative. And you have Broad Idea removing the need for the traditional private law course of action. And the question is then, what happens if you stack them one on top of the other? Now, I do absolutely understand the argument, but it leads to somewhat surprising results, it's fair to say, and therefore one, I think, is entitled to say, well, look, are there some other limitations inherent in the structure that prevent that really rather surprising outcome?
Well, my Lord, I accept the principle of that one's entitled to ask if there are other limitations. On the point about the cumulative broadening, in my submission, for present purposes, the really significant development is the decision in Broad Idea. And to some extent, we're working through the consciousness appeal, one of the consequences of that decision. But of course, part of the background, part of the rationale that Lord Legate sets out there is all to do with the justification, the broadening, the freezing, the reach of the freezing order jurisdiction, and all the reasons why that's appropriate, given how the world's developed. And of course, an important aspect of that is its international.
And can I ask this, so far as this argument is concerned, because one of the responses will be, when this is now true of anti-suit injunctions and search orders, although there you would get an entirely different argument that they're now founded on the Civil Procedure Act 1997, but or is it something that you say arises specifically in relation to freezing injunctions, and if the latter, is that because of section 37.3 or because of Broad Idea and what it tells us about those, or a combination thereof?
It's the latter, and it principally relies on Broad Idea. and that analysis is informed by the circumstances in which Section 37(3) was enacted. As I said at the outset, I don't rely on there being any hard and fast distinction between subsections 1 and 3. Plainly, they work together. But I do submit that the effect of broad idea is that there is a particular analysis relevant to a freezing injunction that doesn't apply to other types of injunction, and it has the consequence.
Because they are not ancillary
Yes.
to a cause of action.
It's about the meaning of the word allows in the context of Gateway 20. That's what I say. As I say, I accept there'd be much greater force in the argument that where one has an ancillary injunction, that what allows the proceedings, even for the injunction to be brought, is the substantive cause of action, and not the statutory power to seek the injunction. It's still a statutory power.
Of course, Gorbachev, it was the substantive proceedings that allowed the Section 33 to be brought, but that didn't.
But that may be particular to Section 30. I don't ask. I rely on the position as it relates to freezing injunctions.
Yeah.
I do say there are reasons why. This comes on. Actually, we respond to the next subtopic, which is this floodgates type arguments. There are important reasons why, by deciding that Gateway 20 is available in the case of a freezing injunction, and even then, the circumstances in which that matters are quite narrow, the court is not going to be opening the door to its use for a whole load of other types of application. It may have the effect, of course, that people are encouraged to make those arguments, and those arguments may then need to be considered in due course. But in my submission, there are no obvious examples where the reasoning based on the particular nature of the freezing injunction and its interaction with Gateway 20 would necessarily mean that that gateway is available for other types of injunction or application. And for example, the anti-suit injunction example, that takes one into arguments about the true nature of the anti-suit injunction and so on and so forth, which are for another day.
Long-standing problem
Yes.
with the serving a vexatious and oppressive anti-suit out of the jurisdiction, because
Yes.
Contractual ones are easy enough. There are a multitude of possible gateways.
Yes, and one can imagine that there may be a persuasive argument that Gateway 20 should be available in those circumstances, and indeed that's a desirable outcome. But that's all for another day and raises a set of complicated issues that
For another visit to Manchester.
But so in that case, it's hard to distinguish in that category of case, which is the anti-suit for vexation, so non-contractual anti-suit. There wouldn't be this limitation about saying, well, it's just ancillary to another cause of action.
Well, I agree, but there's then still the arguments about what its basis really is.
Yeah, and also we do treat vexation and oppression as a category of equitable wrong, giving rise
So
to
it might
equitable
be that.
compensation. So it might be that.
But this is then, it might be said, this is making this idea of whether it's ancillary or not do quite a lot of work in the context of a rule which talks about whether enactment allows proceedings. And section, as I understand your argument stripped right down, you say, well, a claim can include an application notice, see Gorbachev. A claim for an injunction is made under section 37 because it's a statutory power of the court. Therefore, it's a claim made under an enactment, Section 37, which allows proceedings to be brought, and the proceedings are just the proceedings on the application note.
Exactly.
It's quite hard to see how how this idea about it being either ancillary or not can be brought within the wording, I think.
Well, Lord, it's the word allows. That's what I say would be the nature of the distinction, because in the case of the freezing injunction, in the light of broad idea, it is only, I submit, Section 37 which allows those proceedings to be brought. It would be wrong to look for any other source that allows those proceedings to be brought, in the sense that it's certainly not the cause of action, as Lord Legate says. That's no more than something that's evidentially relevant to those proceedings. In the case of an injunction that's ancillary to the cause of action, in my submission, there is a plain decision. I'm not suggesting that any of these points don't remain open for argument, and I'm not seeking to resolve that argument. All I'm saying is that there is a significant distinction between those situations, because one can well see the force in the position that it's not Section 37 that's allowing the proceedings for that ancillary injunction to be brought, because it is necessarily ancillary to and contingent on a substantive cause of action, and it's that substantive cause of action that allows the proceedings to be brought, in which one seeks the ancillary remedy of an injunction.
So you'll say, your answer to my point is to say, well, leave aside ancillary cases. You say in non-ancillary cases, in other words, where it's a self-standing application, it can only be under the statute that the proceedings are brought, and therefore it must be that the statute is an enactment which allows the proceedings to be brought.
That's precisely my submission, my Lord. Yeah. And I don't seek to make any wider submission about where that might apply outside the context of a freezing injunction. And
but I think we do have to, the floodgates argument and the surprising consequences do have to be addressed.
I accept.
And you will want to look for a control which does not cut out your application, obviously, and so you floated ancillary versus not ancillary as one. I think there are difficulties with that on the linguistic analysis you adopt, as Miles said. I think experience has suggested that forum convenience has proved to be a rather poor control test, because courts have a surprising tendency to imagine that they are a convenient forum for claims. A third possibility, the one I canvassed, is do you need more in the nature of an indication and the enactment in question that it's right conferring or claim conferring? I see difficulties with that as well. But I wonder if we can duck the question of, is a control necessary if you're right, and if so, what it is?
Well, I do rely primarily on that, in that respect, on forum convenience control. I accept that may not be a perfect control, but I pray and aid the authorities I took lordships to.
Yes, but I mean, that is the sort of the peak example of where you can have a road traffic accident abroad, and the pain and suffering you bring back with you at the end confers the gateway, and then the courts decide that England and not Egypt is the convenient place to hear the dispute. Lord Legate, in his dissent, I think, thought that was showed the dangers of allowing forum convenience to do all the heavy lifting, didn't he?
But my Lord, that's a position that's already been reached and has been subjected to academic criticism. But there's no doubt, one looks at the latest round of broadening of the gateways, and we're already in territory where there's a very large number of claims that can pass through a gateway that have quite tenuous connections with the jurisdiction.
That's
and the
Lord
heavy
Justice
lifting.
Miles's fault, I think.
combination.
It was against that background, in my submission, it would do an injustice to be left with some anomalous cases. This is actually a situation in which, in my submission, there is quite a compelling justification for there to be a jurisdiction. And I've not put this in terms so far, but what I essentially say it is that in the case of freezing injunction, of course, what one's concerned with is safeguarding the administration of the court's process, potentially, of course, also the process of another court, but leaving that to one side, in terms of protecting the integrity of the English court's process. That of itself creates an extremely powerful jurisdictional nexus when it comes to injuncting a person who is acting, albeit outside the jurisdiction, to interfere with that process by dissipating assets.
And on that point, you might say, because broad idea shows that it can be a judgment from anywhere in the world, that you're protected, or a prospective judgment that is being protected. But it might be said, I suppose, that that's one of the things that goes into the forum non-convenience exercise.
Yes.
And the fact that it's an English judgment is one of the relevant factors there. Whereas if you were coming on your facts to try to protect a prospective judgment in Germany, it might be, you might have less of a case on forum non-convenience.
Well, yes, and also one would say that one has to have regard to the impact of Section 25, notwithstanding what Lord Legate said in broad idea. And that might also have an impact on the, well, obviously in terms of the gateways, one has the specific gateway for those claims. But all of that can be done at the forum convenience stage. I accept that there's a risk of, that there's an administrative inconvenience where one is shifting more of the burden onto forum convenience disputes. But actually the circumstances in which this arises are quite narrow in view of the fact of what is already provided for, in particular because of Section 25 of the CJJA. So that deals with the situations in which it's in support of proceedings elsewhere. Generally speaking, the freezing injunction is going to accompany proceedings in this jurisdiction, in which case it doesn't arise. Actually, the issue that concerns your lordships is rather specific, I would submit, to the case of the Chadborough injunction and the position now reached in the light of broad idea in relation to Chadborough injunction. And actually this oddity that there seem to be routes for a prejudgment Chadborough jurisdiction to be served out by the necessary and proper party gateway that are, I think, at least to an extent accepted. And it's an oddity that the post-judgment position should be different. Of course, ultimately, the way these types of points feed in to the analysis is somewhat secondary, but perhaps they all feed in as floodgates points. I accept that that's a relevant consideration in terms of the construction of Gateway 20, but the overwhelming consideration is what the express words of Gateway 20 provides and how when one applies those in the context of the freezing injunction properly analysed. It's hard to see why Gateway isn't available. My lords, I've not kept a sufficiently careful eye on the time, but I think the effect of those exchanges has been to address most of the remaining points under ground one. If I could just have a moment. Yes, there was a related point, floodgates point raised by the first instance judge in terms of the use of, in combination with Gateway 4A, of an injunction as a sort of Trojan horse for all sorts of proceedings. That's partly my point about the freezing injunction, the special nature of freezing injunction, but also, again, one has discretionary principles. That means that one can control. It's really a point about the application of Gateway 4A rather than Gateway 20. And so there are means of dealing with that. Of course, a further control on all this is the additional layer of discretion that exists at the level of the power to grant the injunction itself. And the jurisdictional considerations are relevant in my submission at that stage as well. So as well as the forum convenience control, you've got the discretion on the part of the court to say that at the level of its overall discretion, that in view of the absence of a sufficient jurisdictional nexus, this isn't a case in which the jurisdiction should be exercised. It's really just about enabling power that would have the effect of, if your lordships accept, as I submitted plainly the case, section 37 on any view gives the court a power to grant a freezing injunction, including in the Chabra case, against a respondent outside jurisdiction. All this would do is bring the procedural rules into line with that express intention of Parliament in precisely the way that the Rules Committee, one infers, had in mind in broadening out that gateway to deal with those situations where Parliament has spoken and what it said is that a statutory power should be exercisable against a person outside the jurisdiction. These additional layers about specification of procedures and so on and so forth are an overlay that one doesn't find in my submission a sufficient basis for in the language of Gateway 20 and aren't justified by any reference to policy either for the reasons I've said. So, well, I think that concludes my submissions on ground one. I'm wondering, in view of how things have proceeded, what your lordships feel about the appropriate way of proceeding from here in relation to the proposed grounds.
Just carry on. I think we should. Yeah, I think if you carry on as you were going to in any event.
I'm grateful.
But mindful of the time, obviously.
Yes, I'm grateful. So I'll take them quickly. Proposed ground 2 concerns Gateway 2 in the practice direction, which provides that there's a gateway where, I quote, a claim is made for an injunction. And the first instance judge held that that gateway is confined to a substantive claim, injunction, in other words, as a remedy in substantive proceedings, and that was based on the decision of House of Lords in Skeena, and also by the Privy Council in Mercedes-Benz and Lydock. And he relied on the fact that in broad idea, the Privy Council declined to diverge from those decisions in relation to the BVI rules. I recognise that the appellant might be said to be asking the court to take a bold step by acting in a way that the Privy Council wasn't willing to in broad idea.
Just breaking through the fourth wall for a moment, is this argument being taken largely for the purpose of preserving it in a higher court?
Well, I perhaps to some extent, but we do also say that there are material differences in the language of CPR that would justify your lordships in taking a different approach, notwithstanding the earlier House of Lords decision. Perhaps if I can take the lordships back to broad idea, paragraph tab 40, and beginning at paragraph 64. The analysis at this point begins at paragraph 64. As opposed to earlier, there was a defendant in the jurisdiction, and then there was an individual defendant outside the jurisdiction. But the key analysis is paragraph 67 and 68. And paragraph 67 refers to the principle of stare decisis and says that there's no principle of third time lucky. But in my submission, that does leave the strange position of a disjuncture between the assumed legal basis of the interpretation of the gateway and the legal basis of a freezing injunction now recognised to be true, but of course in relation to which the House of Lords took a completely different view in Susquehanna. The two reasons why I say this court need not and indeed should not feel constrained by the approach taken in broad idea are these. First, as your lordship see in paragraph 68, that approach was partly a result of the consideration of the impact on multiple, similarly but not identically worded rules in multiple jurisdictions for which the Privy Council is the final court of appeal. And that plainly doesn't apply here. But second, and more importantly, the relevant English gateway now has to be construed in the light of what is established as a matter of English law about the meaning of claim for purposes of Part 6 of the CPR, C. Gorbachev. And that is a crucial development in my submission for purposes of this analysis. To make that point good, I could take your lordships to Mercedes-Benz case. That's at tab 17 in the authorities.
And just to capture this, you're saying that once you accept that claims and proceedings per Gorbachev encompass interim applications potentially, then to read Gateway 2 is limited to substantive injunctive relief and not injunctive relief with an interim or procedural character ceases to be correct interpretation.
That's right, my lord, but also in terms of this court's position in view of the earlier decisions, that's a crucial distinction from the position under the RSC, where one couldn't analyse matters in that way. That's really the point. And that's the point I seek to make good by reference to this passage from the judgment of Lord Master in the Mercedes-Benz case. It's at page 349 on tab 17. And it's the paragraph in the middle of the page, beginning just above
Sorry,
paragraph.
which tab?
Sorry, it's tab 17.
17.
Yes. And page 349. And if we could just begin actually at the top of the page. So Lord Mustall says, thus at the centre of the powers conferred by Order 11, so the RC, is a proposed action or matter which will decide upon and give effect to rights. An application for moravian relief is not of this character. And then below letter C, in the paragraph beginning there, this opinion that Order 11 is confined to originating documents which set in motion proceedings designed to ascertain substantive rights is borne out by its language. Thus, the opening words define the extraterritorial jurisdiction by reference to the relief claimed in the action begun by the writ.
Yeah.
So that's the reasoning. And importantly, given a point that my learned friend relies on, what he says at the end of that paragraph, it's true that RSC Order 11 Rule 9 makes Order 11 applicable to the service of an originating summons, but the imprint of Rule 1.1 does, in their lordship's view, remain on the entire scheme of extraterritorial jurisdiction and relates it to proceedings for substantial and not incidental relief. Now, Lords, that, in my submission, it is plainly not true of the CPR regime as it's already been interpreted by this court in Gorbachev, because that regime is all by reference to a definition of claim that encompasses a procedural application. So that's why I say
We do have certain avowedly interim or procedural gateways. We have the Goodman gateway, just of that character. And I suppose section 25 of the CJJA gateway. Isn't there a costs, third-party costs gateway as well?
yes,
Don't worry
there
about
is.
this. I think
Yes, and there's the yes. But well,
perhaps there are exceptions to a starting point, which remains as Lord Mustall described. We've slightly
my lords, well, in my submission, that would be a further stage of the analysis, because my point at this stage is simply that for purposes of the CPR, we're concerned at the starting point. The starting point in the RSC is, as Lord Mustall pointed out, was the framing that's confined to that's confined to a writ, whereas in excuse me, in the case of the CPR, the framing is by reference to the word claim, which, as now defined as a matter of settled law, encompasses the procedural application, and so it can't be right that in construing the gateways provided for under the CPR, this court is constrained by how the House of Lords and Privy Council construed the scheme of the RSC. That's the starting point. And if one then takes that as the starting point and asks how one construes the provision at issue here, and under Gateway 2, it provides a claim is made or an injunction, and that word claim, we saw this in the specific passage of the Gorbachev decision earlier, has been held to encompass a claim of a procedural nature. And if one sets, sorry, let's have some water. If one puts, excuse me, if one puts to one side that aspect of the reasoning based on the construction of the RSC in the old cases, in my submission, there's no remaining rationale for construing that gateway, the express words of that gateway of the CPR, as limited in the way that the predecessor had been held to be under the CPR, under the RSC. That's the point.
And what are you looking to stop them doing within the jurisdiction, moving assets here? dissipating assets that are in the jurisdiction.
Yes, we
How
say
does
that.
get your worldwide freezer? Is this gateway 4A, which I'm happy to say is Lord Hamlin's rather than Lord Justice Miles or myself's innovation, but is that then overlaid to say overlapping issues?
We accept that we'd have to rely on Gateway 4A as well, in conjunction with Gateway 2. In relation to that,
That does feel a little bit Trojan horse-ish.
well, I accept that it risks being Trojan horse-ish, but one's brought back to points about the court's jurisdiction to restrain use of those types of provisions, which anyway the court is left in the position of having to do, because it's already this gateway that has very wide potential application. And
I mean, one way of looking at that is that if it arises out of the same or closely connected facts, that seems to be the claim for the injunction.
yes,
And if the injunction is to stop you doing things within the jurisdiction, how can stopping you doing things outside the jurisdiction arise from the same or closely connected facts? They
Well,
seem to be different facts.
they're closely related facts, because the facts one will be concerned with primarily are those supporting the risk of dissipation. The facts are not those relating to the location of the assets.
Well, it might be argued that the claim is the claim for the injunction, which is to restrain the defendant from doing things.
Well, I see the argument, but in my submission, primarily the claim is to, in this situation, the claim is to restrain the defendant from dissipating assets. I accept that then there is a distinction, a factual distinction, between the basis of restraining that dissipation in the jurisdiction and worldwide. But usually that mainly has to do just with the location of the assets, which is a comparatively minor gloss on the risk of dissipation that's usually the heart of the basis for the injunction. So, and my learned friend, I think, praised against me various cases referring to the court's caution about permitting the 4A gateway to be used in a Trojan horse-ish way. In my submission, those authorities help me because they explain how the court can, on a reasoned basis, exercise control on the facts of the given case to ensure that there's not a use of the gateway that results in a claim being served out without any sufficient jurisdictional nexus.
Can you just remind me, was this argument run below about 4A?
Yes, it was. I think it's fair.
In connection with this, with Gateway 2.
I thought it was, but I'll need to check that. I think the judge referred to it in connection with the second proposed ground of appeal.
I'm wondering whether it was run in respect of this argument. So anyway, you can check.
Yes, of course, we anyway appeal to the extent of the domestic injunction.
The wording is, I think, the same, isn't it, of 2 with that in the BVI.
I accept that.
It's materially the same, isn't it?
But there's no indication that the arguments were of the kind I'm making were wrong about the distinction.
Well, no one seems to have had this point in mind about whether an application notice is a claim.
I think that's Gorbachev that really
Exactly.
already made that point, which came afterwards.
So,
And
as
then
I
going
say,
back to the point, sorry, I know this is reverting right back, but to the Gateway 20 point, because it might have been expected in broad idea that someone would run that point, but it sounds as though there wasn't a Gateway 20.
that's my understanding, and I'll check, but I think I looked into this before, and I think that was, so I wondered
Right.
why that wasn't run, and I think that's the answer. And I think there has subsequently been such a gateway introduced in the BVI, in fact, but I just didn't find the time. Lord, so much for proposed ground 2. Proposed ground 3 concerns gateway for property within the jurisdiction. It's Gateway 11. It's available where, and I quote, the subject matter of the claim relates wholly or principally to property within the jurisdiction. We say that the judge ought to have found that that gateway was available on either of really 2 possible bases. Either that the subject matter of the application relates at least principally to the judgment debt, which is an English judgment debt, or as regards Mrs. Bleakley, that it relates to other assets that she has or had in the jurisdiction. Dealing first with the judgment debt, the judge accepted, and it's not an issue on this appeal, that the Broadoak judgment debt is property within the jurisdiction, so that's the starting point. And the analysis in relation to that is that the judgment is a chosen action, giving the appellant rights to be paid in England. See Lackatamia Shipping and Sue at paragraph 75. I'll take the court to that decision in just a moment. But the first instance judge went on to hold, paragraph 66 of the first instance judgment, that the application is more directly concerned with the assets held by the respondents and their availability to meet the judgment, not the judgment itself. In my submission, that again ignores the impact of a true analysis of the freezing injunction as set out in broad idea. As I've already shown the court, the enforcement principle is central to the rationale for the injunction. And therefore, on any view, a Chabra injunction principally relates to the judgment debt that the injunction exists. The injunction serves to protect by way of the injunction.
The existence of the judgment debt is not in dispute, nor could it be on this application. It's raised judicata. So what is the argument is about is trying to freeze assets against which the usual processes of execution in the form of third-party debt orders or charging or sale orders or whatever might be executed. So there are sort of intermediate steps, aren't there, between the judgment which is not in dispute and no one is going to be arguing about its existence and the relief that's sought in the freezing order.
Well, in my submission, no, because on the freezing order proceedings, what is really an issue is whether the judgment is endangered, or at least the enforcement of that judgment debt is endangered. It's not any issues about the enforcement itself. It's whether there's a justification or requirement for the court to intervene to protect those rights to enforcement of the judgment, separately from the enforcement process and pending that.
But you've got to identify assets amenable to execution, don't you? The freezing order only attaches over assets that are amenable to execution. So it is premised upon the availability of the means of execution of the judgment debt against those assets.
I accept that connection, but what I say is, nonetheless, what one's concerned with here is the focus of the particular proceedings. The question of characterising the particular proceedings.
It's the subject matter, isn't it? We have to identify.
Yes, precisely. And the subject matter is, in my submission, really about the risk of dissipation as it relates to the enforcement principle. That's what one takes from a broad idea. The rationale for the court intervening to protect an interest of the applicant is, in respect to the enforcement principle, the restraint of the risk of dissipation. So
that can't be. The risk of dissipation isn't, as it were, on its own. It can't be said to be the subject matter of proceedings. The subject matter of proceedings, if it's to do with property, must be the property over which, prospectively, you may be able to execute your undoubted judgment. That must be the subject matter. And maybe there are questions that arise in relation to things like dissipation to decide whether you can have an injunction. But the subject matter must be the property, mustn't it? The underlying property.
Yes, I accept that. The wording is slightly awkward because the subject matter of the claim must relate principally to the property, and yes, and that property is the judgment debt. That I accept.
Well, no, I wasn't postulating that actually in my question. I was suggesting that the property is whatever the property is in the hands of these respondents, or over which they have control, which prospectively you want to get, to put it colloquially, you want to get your hands on to satisfy the judgment.
Well, I'm sorry for misunderstanding. Yes, and that was the conclusion, first instance, judge. But in my submission, that doesn't properly take account of the rationale of the freezing injunction for the reasons I've given. Just to seek to make that point good, I take the court to the Lactamia shipping case. That's at tab 45. And if I could begin with the headnote. That was the case where the claimant brought claims against the third defendant, a lawyer, alleging unlawful means conspiracy and so on and so forth, in relation to violation of rights in judgment, and in particular alleging that the third defendant helped first and second defendants to dissipate assets in breach of a freezing order. I emphasise the words after that, thus reducing the value of the debt which the first defendant owed to the claimants under various English judgments. So that's the essence of the claim, and I could ask the court to turn to paragraph 75. And I should say this is a judgment against Justice Bryan. And paragraph 74 and 75 is analysis of the application of the property gateway to that claim. And the punchline at paragraph 75 is that the debt owing pursuant to judgments is a chosen action, giving rights to be paid in England, as I referred to earlier. Accordingly, I am satisfied that Lactamia, the claimant, has established a good arguable case that its claims against D3, each of which are connected with or founded upon judgments, pass through the property gateway. In my submission, the same analysis applies to the judgment debt here. The only difference on analysis is that this is a claim for an injunction to preempt the damage to property in the jurisdiction in the form of the judgment debt, rather than seek compensation where that damage has already occurred. And that's why I say that the analysis of freezing injunction jurisdiction and its rationale is crucial to construing the subject matter of the claim, subject matter of the proceedings for the freezing injunction. And on this basis, in my submission, the judge was wrong to focus on the underlying assets that would be enforced against, as opposed to the judgment itself that's being protected by those proceedings.
It looks as though the only argument before Mr. Justice Bryan was whether a judgment debt was property. He appears to have treated the answer that it was as conclusive of the potential application of the property king. It's obviously not the limit of the argument you're facing here. The argument here is that looking at the nexus and whether it's sufficient to whatever the property gateway requires in terms of the link between the property and the claim.
Well, I'd accept that. I'd accept that, and I accept that the reasoning is short on the point. But nonetheless, of course, it would have been one would have expected the point to be considered as far as it was of concern.
It's not entirely easy to understand the reasoning, because the debt, even if the debt is property, the debt is just the same. It's just that someone's taken some steps to frustrate its enforcement, I understand it.
Yes.
So it's very compressed reasoning, if it is, if that is the reasoning.
What I take him to have in mind is that the property is the shows in action represented by the judgment debt. The wrongdoing, or alleged wrongdoing by the third defendant that's in issue in the claim is damaging that property in the sense that it's reducing the value of the shows in action by dissipating, by undermining the ability to enforce that judgment.
Well, one can see quite readily why that might give rise to a tort claim and conspiracy.
Yes.
But it's a bit harder, I think, to understand how that is a claim relating to property, but there we are.
Well,
and the reasoning, as you say, is very short.
Yes, I accept. Lords, I'll move on to the second aspect of ground 3, and that relates to property within the jurisdiction of Mrs. Bleakley, in particular a sum of around £5,000 still in an English bank account, and also a sum of around £3.8 million that was previously in a jointly owned English bank account, but which was no longer so by the time of the application. The judge recorded that reliance on those assets was raised for the first time in responsive oral submissions at first instance, and he was, and I quote, not prepared to admit the new argument. That's paragraph 68 of first instance judgment. My learned friend's first point in relation to this is that the first instance judge made, in effect a case management decision, which in itself the appellant hasn't sought to appeal. In relation to that, I suggest that's not the right characterisation. The appellant appeals against the judge's finding that the property gateway wasn't available, which was not a case management decision, seeking to rely on an argument that was in fact raised, albeit only in a reply and orally at first instance, but is therefore not a new argument.
We don't have the benefit of the judge's view, not because he decided he didn't have to decide it in the light of some earlier decision, but because he took the view that the point had been raised too late to make it appropriate for him to decide it.
Well, no, I have to accept that.
That is a case management decision.
I mean, the opposite view would make appeals something of a free-for-all, wouldn't it? Because you could always say, well, the judge, it was raised a bit late for the judge to address it, so he said he wouldn't, but some time has now passed before we've got before the Court of Appeal. Let's have another go.
Well, the difference here in my submission is that the judge did make a substantive decision on the relevant point, i.e. the non-availability of the property gateway, and that decision is appealed. Obviously, there's no dispute to our right, as it were, to appeal against the first aspect of that, the question of the characterisation of the judgment debt.
If the judge had looked at it, he might have raised arguments about de minimis, or if he'd considered it, he might have gone on to say that that in itself wouldn't make it a proper case for service out. None of those arose because he reached the view that it had been raised too late.
I have to accept that's, in practical terms, what happened.
It's not actually, sorry, just to follow that, it's not just de minimis, is it? The rule talks about wholly or principally.
Yes.
And so that's actually part of the rule, which might well engage in evaluative
Yes.
exercise.
I accept that as well. The judge, of course, as part of his reasons for not admitting the argument, as he put it, he raised the sorts of points that would need to be considered by way of, I suppose, identifying difficulties. But it's true he then didn't analyse them. Lord, since they're brief, I will make they're very brief. I'll make my substantive points if I may. Nonetheless, on the substance, my learned friend says, echoing points suggested by the judge at first instance, not analyse reasons your lordship say, there are two difficulties with a reliance on those assets, those two cash assets, the £5,000 and then the larger sum, £3.8 million formerly in a bank account. He says that the £5,000 is de minimis and can't be used as an anchor, and he says that the gateway doesn't look to assets formerly in the jurisdiction. Taking the latter objection first, not least of the other time, I don't invite the court to find, and in my submission it need not find, that it's sufficient for the gateway that in itself that there was historically property in the jurisdiction. This isn't that case, in the sense that this is a case where there is property in the jurisdiction. There is, accepting for these purposes, the relevant time is the time when the application was made. There was at that point property within the jurisdiction. That's to say, the lesser amount, the £5,000 in the bank account. The objection taken is that amount is said to be de minimis. But that objection is largely put as a matter of discretion, and And I don't argue with the principle that the amount of the property in the jurisdiction, when sought to be combined with reliance on Gateway 4A, plainly is highly material to the exercise of the court's discretion. So that I accept. But in terms of the satisfaction of the gateway, that is done, I would submit, by the existence of the £5,000. That is that's a basis for bringing the claim in relation to that property, and the domestic freezing injunction to that extent in relation to that property. This is where we accept we have to have regard to Gateway 4A. In that context, I do submit that it must be relevant to the exercise of the court's discretion that there was historically a much larger sum formerly in the jurisdiction, and which is part of the factual background indeed to the matters complained of. It's to some extent the pony left in the field type of situation. That's a matter that the court can have regard to. So in my submission, the judge ought to have held that that sum was available. Of course, this is the aspect of the proposed ground for appeal that the new material would be directly material to. So, my lords, those are my submissions. I see the time.
No, well, I think you've admirably got to 1 o'clock and made all the submissions I think you want to at this present time.
Well, might I use the 2 or 3 minutes we have left just to make 2 short points? The first is just to correct my interjection to my Lord Justice Miles. Looking at a 2000 version of the ECCPR, there is a Gateway 10, which is claims under an enactment conferring jurisdiction on the court, which is in similar terms to our enactment gateway. I suppose on my learned friend's view of the world, that makes the decision in broad idea at least a missed opportunity. But there we go. My learned friends can check that over lunch, and I will send them this link so they can have a look as well. The second point I just wanted to make before lunch was that it would be helpful, of course I want to know the answer to this, but it would be helpful if the court can give an indication on permission after lunch. And the reason I say that is because there are at least 3 fairly large topics that might fall away depending on where permission lies. One is the question of when property needs to be in the jurisdiction. I think, based on what my learned friend has just said, it may be that I need to spend less time on that than I thought I had to. The second is the issues relating to gateways 4A, and the gateway my learned friend didn't mention, which is the necessary or proper party gateway, because he also relies on that to bring in the second respondent, so it's not just 4A.
We've not had submissions in
Indeed.
this skeleton or already on that.
Indeed.
Difficult topic,
Indeed.
and at the moment, for my part, I don't regard it as a point being run on the appeal.
Indeed, my lord, and it would open up, and that may save me the unenviable task of explaining or trying to explain my view or my client's view of your decision, my lord, in Alsari. So that topic goes off the table. And with those things off the table, then I can spend more time, obviously, on the enactment gateway, which we would suggest is the real battleground. But obviously, it's a matter for you, my lords, as to whether you're able to do that after lunch, and if not, then
We'll
I'll
see where we get to at that
Indeed.
stage.
Thank you.
Court rise to table.